Well, good morning to those of you who are joining us live and to those of you who are joining us via recording. My name is Seth Stander, and I am the Community Aging Specialist for HHCI CARES, the division of the Hope and Healing Center and Institute that focuses on caregiving, aging, resilience, ethics, and spirituality. Today is February 12th, 2024. It is right around the 10 o'clock hour, and we're going to spend the second of our 4 Aging with Grace sessions on legal considerations having to do with aging, whether aging in place, aging in long-term care, whatever the environment may be, preserving one's autonomy and dignity with preparation along the way. We're going to have 2 other Aging with Grace sessions coming up on the 19th and on the 26th. And if you haven't had a chance to register for those yet, you can go to our website to hhci.org, click on the Events tab, and you'll see there, either by listing or by calendar format, the click-through links to Eventbrite, which allowed you to register for today's session. If you joined us last week for the first of these 4 sessions in the 2024 calendar year, we will be focusing in on understanding living options and paying for aging, the 3rd and 4th sessions after today's. So let's go ahead and start out with a disclaimer and remind anyone who is watching or listening to this that what comes next is an overview of legal estate options here in the state of Texas. We are not attorneys. We, in fact, invite you, encourage you, beseech you to consult an attorney, especially an attorney with skills and experience in family law, in estate planning, for specifics related to your own issues. And if you are in Texas, outside Texas, your particular locale. So let's go ahead and begin today by asking the question, do you have a will or a trust in some form? And if the answer to both of those questions is yes, terrific. You have done the bulk of the work that we are going to talk about in today's session, although refreshing one's will, refreshing one's trust, the parameters under which each operates is always a fine idea. So we hope you'll stick around if you have those in place already, just to remind yourself of the core components that you may wish to consider, including, let alone revising over time. We're going to focus first on wills, and to do so in what seems like a bit of a backwards way at first, which is to say, if you don't have a will, well, don't worry about it, because the state of Texas has you covered. If you are to die what is called intestate without a will provided, and it is, well, I'll leave it to your discretion to decide whether the Texas Estates Code has gone ahead and done a fair job of going ahead and determining just how your worldly possessions will be divided amongst those who qualify as your heirs. So with that in mind, we're going to go ahead and we're going to look for a few minutes at the intestate laws according to the Texas Estates Code. There is a method to this, so I hope you'll run with me on it. Now, as we look at the first of a couple of slides on intestate distribution here in Texas, let's be clear that if you only have a spouse as an heir, a child or children as an heir, parents only as heirs, siblings only as heirs, you can see here the general categories are pretty clear. Everything that belongs to you after your estate has been settled and all debts have been cleared are going to go to those specific categories. Again, assuming that there is no mix of those four categories of spouse, child or children, parent or parents, sibling or siblings. Everything you own will simply go to them. I wish it was a simple, smooth, and expeditious process, but probate often takes a great deal of time, and we will define probate for you in just a few minutes, especially if it's not a term you're familiar with. But if you are intestate, and you have a mixture of potential beneficiaries or heirs. Now we begin to go ahead and see how the state has done its level best to try and distribute fairly your worldly possessions. So, looking under the category of spouse and children of spouse, so ultimately, you and your spouse there is on the books in Texas what is called community property laws, which is to say that um, everything that you have acquired since you became married to your partner, that is something that remains firmly in your partner's possession should you die intestate. Now, as far as separate personal property, here we're not talking about your partner's personal property. We are talking about your own. And a third of the separate personal property that you owned before your death would be available to the spouse in terms of its overall value. And your spouse would have the right to use the real estate, assuming that you have ownership or in the process of paying a mortgage on your real estate as their primary residence. In other words, there's no need to immediately sell your home. That's a decision that can be made by your spouse, surviving spouse at this point, down the road at a time of their choosing, if they so wish. And then what about everything else that you might own outside of those parameters? That will be what is distributed to your child or children. And if it is children, it will be distributed from a monetary perspective in the most equitable way possible, liquidating items of worth, taking items that are already liquid value, and making sure that they're distributed as evenly as possible. So, what if you have a spouse and you have children who are not the children of that spouse? Perhaps you remarried after the your first wife or first husband had died, and so ultimately we're looking to make sure that they are protected as well. Well, here you begin to see a separation in terms of who has the right to community property. It's divided according to the intestate rules of the Texas Estate Code. It's divided half and half. Half of that community property will go to the spouse. Half of that community property will go to the child or children who are not the children of that spouse. And then you can see it's pretty similar that a third of the separate personal property you owned while living will go to your spouse. The children who are not the children of the spouse are going to get what's remaining of that. And the surviving spouse, just like above, has the right to use the real estate that they and you, now deceased, call home and can make decisions about it at some point in the future. So, what about no children in the equation, but you have a spouse and you have a living parent or parents? Well, ultimately, that spouse is going to get all community property and all of your separate personal property, and they are going to receive half of the separate real estate. Notice it doesn't say that you, the surviving spouse, have the right to stay in that real estate. That may be something that comes up. Perhaps the parents, who, as you can see on this chart, get everything else that you used to own while living, um, may go ahead and say, our half of the separate real estate, because that's part of the everything else category, is something we'd like to liquidate. And at that point, you would need to be prepared for a sale of that home and relocation after receiving the proceeds. Um, Again, this may not be your choice, and it may not be what your spouse, now deceased, had intended to see happen to your household. But without a will, the state of Texas is doing the best it can and has set cookie cutter parameters under which they operate based on the categories of beneficiaries slash heirs. So if you have surviving one parent and you have sibling or siblings, but no spouse, ultimately it becomes a half and half split, as you can see on the chart here. Half of the separate property to the parent or parents, and the remaining half of that separate property is either, if it's just one sibling, all to them, or multiple siblings, they have equal shares of that, which, by the way, almost guarantees that unless everyone comes together to go ahead and try to work out some type of legal and financial arrangement, that whatever property you might own is going to be sold. And then ultimately, you can see a similar type of arrangement if you have a surviving spouse and a surviving sibling or siblings, where just like above with spouse and a surviving parent or parents, community and separate property is going to go to the spouse, but everything else, including half of the real estate, is going to go to the sibling or siblings as well as to the spouse. And because of that division, there is a possibility that despite the best laid plans that may have been spoken about but not put down into a legal document, the real estate may end up being sold despite the deceased person's wishes. So we've already begun to go ahead and to answer the question, what is the purpose of a will? But I think it's worth reviewing in greater detail. A will enable you to distribute your property to your chosen recipients. And your chosen recipients can be people. It can also be institutions or organizations. So we've talked about spouses, children, other relatives, such as parents or siblings. But there's also non-relatives, those people with whom we have bonded through life experience, charitable organizations. Of course, I would imagine that anyone who is watching or listening to this in real time or by recording is aware of the places that may immediately come to mind whenever I say charitable institution, charitable organization. It could be your faith community. It could be a nonprofit in your community that you have a particular desire to continue to see thrive. Whatever you decide is your business, and the purpose of a will is to make sure that your decisions are honored. Should you still have minor children at the time of your death, guardians for those minor children would be named in your will, and their responsibilities for your children's upbringing, safety, security, any detail about the values, ethical, religious, and more that you would want to ensure your children are aware of as they are being taken care of as minors by these named guardians. All of that can be detailed in a will. And of course, talking to the people who would be on deck, if you will, to serve in a primary role. And if they're not available, those available to serve in a secondary or tertiary role as your child or children's guardians, should they remain as minors upon your demise. All of that can be spelled out. And of course, provisions ideally are made to discuss in detail just what they've agreed to and to make sure you have their full participation and support. You can create a will in order to plan for estate taxes. Now, if your estate is worth just by yourself over roughly $12 million, or if you are a part of a married couple, just over $24 million, then ultimately you are going to go ahead and you're going to need to divide out whatever the current rate at the time of your death is being charged for estate taxes, and making sure that that money is readily available either in liquid form or through the liquidation of tangible assets up to and including your real estate in order to make sure that that tax burden is fulfilled. Um, Now, that estate number may change over time. What doesn't tend to change much in our society is that there are very few of us who have assets exceeding $12 million on our own, 24 million as a part of a married couple. And if you do, the odds are very good that you are well acquainted already with various types of financial instruments, such as trusts, as well as a detailed, comprehensive document that constitutes your will. And that's great. But as I said before, whether this is something you already have or not, it's really important to review it every few years or as significant life events emerge or are upcoming to ensure that your will and your various trusts, should they be in place, are up to the task of your current status in life. Ultimately, when it is time to have your estate managed, for the purposes of executing a will, an executor or an executrix will be named in that will, ideally. Again, if there is the need to have a primary executor or executrix and a secondary, then the more detail, the better. Their life circumstances might have changed in the months or years or decades since this will was drafted. But whoever is taking on that responsibility will need to go ahead and to make sure that your will makes it successfully through the probate process. We're going again to talk about probate in more detail, but I think it's important for us to establish the requirements for a will involve both capacity in two different forms you see here and intent. And to be specific about that, let's talk first about legal capacity. In other words, that we occupy a particular status or relationship with another, and that we engage in a particular undertaking or transaction with another. The most obvious examples of this are marriage, parenthood, but it could also be by virtue of going into business with someone or establishing some type of charitable foundation that distributes funds, your relationship with that foundation, whether you are directly or indirectly involved in the operations and distributions of said funds. Charitable organizations might go ahead and ask you to complete what is called a bequest, where again you've put them in your will, and the amount and the form of the gift that will be made after your death by way of the bequest that's in your will is spelled out in detail. Now, beyond occupying a particular status or relationship with one another, or engaging in a particular undertaking or transaction with another, you have to have what is known as testamentary capacity. That is to say, both the legal and the mental ability to both create and to update, to make or to alter, in other words, a valid will. And finally, testamentary intent. That is to say, that the purpose of creating this will is to make sure that your wishes in contemplation of your mortality, we are all mortal after all, of all your property will be dispersed among beneficiaries and or heirs, is clearly stated, let alone uh, desire for you to have control over the process of said disposition. Now, in order to accomplish that, there are a few formalities that need to be considered. And again, we encourage you to get much more into the details of this that are relevant for your state, your municipality, with a licensed attorney with experience in estate planning, in family law. But in general, we are talking about an attested document, which is to say, in writing, your will would be signed by you or another person at your direction and in your presence. And it would be, here the attestation, it would be attested in your presence by at least two credible witnesses who will not benefit in any way from what is contained in your will, who are at least here in Texas over the age of 14. Your mileage may vary on a state by state basis, but we're going here with the current laws in Texas in terms of what constitutes a credible witness. In this case, you need two of them. Over the age of 14, no benefit gained by attesting in your presence that this is a valid will. This next bullet point is crucial. Any attorney that doesn't go ahead and just throw this in automatically when they discuss the attestation part of writing and witnessing your will being completed, don't use them. And that is called the self-proving affidavit. It's a must. And the reason for that is because at the time that the will is properly signed, that self-proving affidavit, which is going to be signed by the people who attest in your presence, those two credible witnesses, that this will is valid because it was properly composed, properly signed, properly witnessed, eliminates the need for them to serve as witnesses during the probate process. This affidavit is enough for you to move forward in the probate process. It is important. The most obvious reason why is witnesses might move and not be easily accessible. Witnesses might have faulty memories, and you want to make sure that you have gone ahead and made sure that that credible witness is of sound mind, as they not only have witnessed the signing by you of your will, but also that the self-proving affidavit is a confirmation of the fact that they were there to perform said task. Ultimately, you can go ahead and beyond any type of formally drafted will, usually with the full assistance of an attorney or some other form of legal services, you can create what is known as a holographic will. Which, by the way, doesn't necessarily mean that you are starting a will completely from scratch. You can have a fully detailed will and then decide that you are going to attach an addendum or addenda, multiple addendums, if you will, to that existing will that go ahead and supersede certain provisions in that will or cover things that weren't covered at the time the will was initially drafted. Being holographic means that whether it's a complete will or it's an addendum or addenda to an existing will, it has to be written completely in your own handwriting and signed by you. Because going back to the issues of capacity and intent, it has to be something that is clearly understood to be created by you, being of sound mind, understanding what it is you are creating to either from scratch or in addition to an existing will, and ultimately that you are not being coerced into doing so. Probate. So in Texas, the probate process is primarily to go ahead and to, first and foremost, recognize that a person has died officially. And due to that death, after a death certificate is issued, to wind up that estate. In order to accomplish that goal, an executor and executrix will have the responsibility to identify the estate. In other words, make sure that they have a clear understanding of everything that falls into the category of ownership by the deceased, gather all of those identified parts of the estate and divide them out in terms of assets and debts. Because one of the things that we collect are bills. Everyone has ongoing bills. Some people may not have certain monthly that they pay any longer for a house or a car and so forth. Um, Whatever the case may be, whether it is a recurring debt like a utility or a credit card payment, or it is a debt eventually being paid down to zero, such as a mortgage or a car note, we're going to try to figure out, that is, we, if the person or persons who are serving as executor, as executrix, to gather all of those assets in order to zero out any debts that the estate has after you have died. Um, Once that has happened, then ultimately a public record of that process is going to be made, and what is left after the debts are settled will be distributed to the named beneficiaries and heirs, be they people or organizations, and so forth. Now, in terms of gathering all the assets and paying out all the debts, the executor and the executrix have the responsibility to also examine categories of assets that will not be subject to the probate process. And this is ultimately, think of it as a process that must involve the court. And because it involves the court, must become a matter of public record. There are certain things that we would prefer potentially to keep private. And a lot of that is taken care of for us, and certain things we need to go ahead and place into a trust in order for that privacy to be maintained. Examples of both of those are right in the middle of this page. For example, insurance policies with named beneficiaries, bank accounts and retirement accounts with named beneficiaries. These are not going to become part of the public record because the provisions that have already been made for the transfer of that wealth upon death, again, assuming that debts have been settled out, is already covered, and therefore there's no need for a court to review it, and there's no need for it to become part of public record. The same thing would apply for any property or liquid assets that are held, and this is a term of legal art that you will absolutely want to hear any attorney you work with name specifically, held in joint tenancy with rights of survivorship. I recognize that for some of you, you may have heard other terms in decades past, but this is the gold standard in terms of the legal term of art that exists today. I can't predict the future, but today, when it comes to shielding those properties, those assets in liquid form that go to someone um, in terms of this joint tenancy with rights of survivorship arrangement. That's the community property. That's the joint checking and or savings accounts. That's the joint ownership of vehicles and so forth. Anything that falls into the category of joint tenancy with rights of survivorship, with that designation attached to it, um, it does not go through the probate process. In other words, doesn't need to be reviewed by the courts, doesn't need to become a matter of public record. Also, it's a very important way of making sure that for a surviving spouse or for anyone who is serving as executor or executrix and is trying to wind up the estate by paying out the debts as one part of that process, that they have access to those funds. But I'd say the more important piece is surviving spouse not having the anxiety of wondering whether they can access the bank account they've shared with their loved one for these many years. And of course, trust assets. You are creating a category under which essentially this joint tenancy with rights of survivorship exists in areas that ordinarily don't have that language included automatically. So when I mention things beyond financial instruments, such as accounts, where we're talking about property beyond, say, a home or a vehicle, this is where everything else that's part of your estate that you want shielded for privacy purposes, you put into that trust. Let's find my mouse. There we go. So, one example of this kind of trust is what's known as a revocable living trust, a revocable living trust, as opposed to irrevocable living trusts. I want to make sure that I'm not accidentally steering you the wrong way. Revocable living trusts, they ultimately, by its very name, as opposed to an irrevocable trust, is a trust that can change over time, but its primary purpose is to go ahead and to be managed by you while you're alive, your spouse, or you can have a combination of trustees in whatever form you wish to have to manage it while you are alive. That enables you to use your assets during your lifetime and to privately, securely, without the need for a court, transfer them to beneficiaries and heirs after your death. As I said, it avoids the probate process. And if you are incapacitated before death, it avoids what is known as a conservatorship proceeding. In other words, trying to determine who is going to serve to handle your financial affairs if you become incapacitated before death. If you've already got multiple trustees, then the trusteeship simply shifts a responsibility to those who retain, I should say, capacity, legal capacity, medical capacity, in order to go ahead and to make sure that the flow of funds does not stop. Now, you can't just create an asset or a trust, I should say, that has no assets. It does require a transfer of assets into that trust. Can't just be created on paper. That would be the equivalent of saying I want a line of equity credit or some other type of mortgage on my fully paid for home. Some people refer to reverse mortgages in such a fashion, which we'll talk about in the paying for aging part of the Aging with Grace series. But you have to have a balance. It doesn't have to be large. Could be as little as $100, maybe, depending on what company you're using and what their minimums are. But there has to be something tangible in there to be managed. Ultimately, I will tell you that for those of you who are facing situations in the near future, and I say within the next 5 years counts as the near future, because that's what the federal government thinks too. If you, in fact, anticipate that you will be spending down an enormous amount of your estate because at some point in the future, you're going to need the level of long-term care that a nursing facility provides. Don't wait until you're within that 5-year period, if at all possible. And again, there's a lot of life that is simply unpredictable. Adverse effects that affect our well-being, our ability to function independently, our need for long-term care in the first place. I'm not talking about those. I'm talking about if life is otherwise filled with overall good health, preparing by having this trust in place years and years and years ahead of adverse event, or ultimately a medical necessity for you to have assistance with what are called your ADLs, your activities of daily living, which we'll talk a lot about in the Understanding Living Options section next week of the Aging with Grace series. If you can manage to get that done outside of a 5-year window, then ultimately your assets are going to be protected from any type of what is called the Medicaid Estate Recovery Program. That is to say, if you utilize Medicaid funds because medically and financially you qualify to have those help cover, along with, say, your monthly applied income, think Social Security, pension benefits, etc., to cover your bed in a nursing facility. Depending on what state you live in, and Texas is one of these states, you may see that is, your heirs may see after your death a desire by the state who distributes that Medicaid funds to pay for nursing facility care if you qualify, to try and recover what they've spent on you in the remaining years of your life after you are dead. So remember that if it is possible, and no one can predict the future, but if you are preparing in a decade in which it is unlikely you are going to need long-term care, and you have a trust put in place years, if not decades, before the need might ever arise, those assets are protected from that Medicaid Estate Recovery Program. Now, as far as your other private creditors are concerned, or if you still owe money that death does not go ahead and eliminate to a government entity, those assets in your trust are not protected from those. But it's the Medicaid benefit in particular that we'll spend more time talking about next week, because if one finds themselves spending down their assets to the point where all they have left is perhaps just a little bit of savings, a little bit of monthly applied income, and not much else in terms of liquid assets. You might still have a home, you might still have a vehicle in your name. And medically, as well as financially, that puts you into the qualification category for Medicaid, covering parts of your room and board, the rest of which you cover with that monthly applied income, minus what's called a personal needs allowance. By the time all is said and done, what that means is that there's, beyond the home, beyond the vehicle, or any tangible item that could be liquidated and then distributed, the worth of it to your heirs, you're not leaving much for the future generation. which may be your intent, in which case, God bless. It's your assets. But by putting them in a trust well before that 5 year look back period is ever a factor, you are in fact preserving generational wealth. So I need you to think seriously about that, even if it seems absurd at this stage of your life to do so because of your age. It is never too early to go ahead and to create a trust and protect assets. Now, in theory, if you have a robust enough living trust, there may in fact be no need to have a formal will, one might argue, in which case you could have what is called a pour over will for assets that just, for whatever reason, didn't make it into the trust, either by intent, by accident, by lack of qualification, whatever the reason might be. I recommend a will along with a trust. And your pour over will, it can be a little bit more robust. But if you have focused all of your energies on making this trust, revocable or irrevocable, as robust as you possibly can to cover as many contingencies as you can, then good for you. Please make sure that you work with an attorney who says, if you've done that but don't have a full-fledged will, get a pour over will in place. If they don't mention it, be careful. So, beyond the will, beyond the trusts, let's spend a few minutes talking about what other documents do I need to have in place well before they're needed, because of life's circumstances. Some of this we talked about last week in terms of healthcare rights and responsibilities. And this is a good time to remind anyone who is watching or listening live or via recording, signing up for any of our Aging with Grace sessions will ensure that you will get a copy of the recording for said sessions along with a copy of the slide deck for those sessions. So that's why we encourage you to sign up as well, so that you're automatically included in the distribution of recordings and these slides. Having said that, if you've gotten a Zoom link from a family member or a friend and said, "Oh, geez, I never signed up," that's okay. If you don't automatically get anything, or if your friend or relative doesn't forward it to you, if you go again to our website, to hhci.org, you can simply go ahead and look up CARES, or under the About Us tab, to get to me, Seth Stander, your presenter, and my contact information will be located there. And you're always welcome to email me directly and request information. We're not keeping this secret. We want you to have it. So if one method isn't working easily for you, then let us know, and we'll make sure that it gets to you directly. Back to our presentation. Statutory durable power of attorney. Now, this is a document that you are going to want an attorney to help draft, and that is going to be witnessed, and a notary is going to affix their seal after it has been signed and witnessed. And it has to do with any and all business/financial issues if you become incapacitated. Until that designation is made, no one should be, without your consent, handling your financial affairs. If you have made such an arrangement, that's great, but no one should have the ability to do so without your consent unless they are named as the primary, and if the primary can't serve, secondary or tertiary durable POA, short for power of attorney. A separately drafted document is the statutory medical POA, or medical power of attorney, with, and this is important, a HIPAA release. HIPAA is the acronym for the Health Insurance Portability and Accountability Act. This is basically going ahead and giving anyone involved in your healthcare permission to share with the people who are listed in that release about your medical issues, to either in full or under conditions that you establish. Again, no one should be making decisions for you if you are not incapacitated. But if you have chosen to have someone consult with you or speak for you, that is your business. But if you are incapacitated, whoever is primary, or again, if they're not available, secondary, even tertiary, medical power of attorney with a HIPAA release, they can talk to the healthcare providers who are caring for you while you are incapacitated and work together with them to determine the best course of treatment, be it aggressive or comfort care based or someplace in between. Now, if you don't have a document crafted, and this particular document can be crafted similar to the durable POA with an attorney if you wish. Ideally, the attorney is doing both. But if that doesn't happen for some reason, you can certainly go ahead and arrange to have a notary affix their seal after it is signed and witnessed by two qualified witnesses. And qualified witnesses for the medical POA and the durable POA are going to be legal adults who are non-relatives. And so just keep that in mind as you're trying to figure out who might best serve in such roles. If you lack a medical POA, the state of Texas currently lists the decision order in terms of what medical providers, who they will turn to, I should say, in order to get consent on your behalf for whatever is determined to be the best course of treatment based on your condition. They're going to turn to your spouse first, should you have one. Your spouse is unavailable or you've never had one in the first place, then child or children. And if it is children, it is going to need to be a consensus building exercise for them to get to a decision about your care. Parent or parents, sibling or siblings, and then anyone else, other relatives, or anyone else in your circle who has identified who is capable of knowing and doing their best to abide by your wishes based on the medical circumstance you may find yourself experiencing. With that in mind, the other two documents that are listed here, which we touched on last week in the healthcare rights and responsibilities section, are the living will, formally directive to physicians and family or surrogates, which explains your wishes regarding end-of-life issues. And like the medical power of attorney, you can go ahead and get two qualified witnesses. You can get a notary if you wish. But ultimately, this is going to go ahead and be a document that your medical POA, should you have one, and if not, the people in the decision order listed above the bullet point for the living will consult along with your medical team when it comes to how aggressive versus how comforting the level of care should be based on the situation you face. And with that in mind as well, should you decide that there are circumstances under which outside of the hospital, hence the name out of hospital DNR or do not resuscitate order, which requires, again, two qualified witnesses or a notary who's witnessing to you the whole signature process, and it requires the signature of a physician. This is what, if you are someone who is approaching end of life, have posted above your bed, on the refrigerator, someplace that's prominent enough so that if a well-intentioned loved one who may or may not agree with your decisions about when and when not to engage in heroic measures sees that you may be unable to breathe for yourself or has noted that your heart has stopped beating. They contact first responders through 911. Said first responders, with a valid out of hospital DNR, can follow your wishes and are not legally obliged. In fact, the legal obligation is the opposite, which is to not engage in heroic measures based on your express wishes in that out of hospital DNR. If you lack that because you're of an age and your physical health is such where you want full measures taken, again, your prerogative. These are all based on anticipating your future needs. And you may or may not make use of all of them as time goes by, or you may, in fact, need all of them depending on how long you live and the circumstances you might face. I'm going to leave you today with a number of different resources, which I encourage you to go ahead and use, especially the first three, to educate yourself further and to stay up to date on any changes that might occur, at least here in Texas, with regards to the legal planning that you may wish to consider as we all continue on the journey of aging. That's why I've listed the University of Houston's Law Center Clinic, the Houston Bar Association's Elder Law Services website, and as a separate publication, the Houston Bar Association's Elder Law Handbook. I encourage you to, again, make free use of these materials. Note the last time that they were edited. And if need be, compare that latest published document or documents that you're reading to whatever an attorney might be able to advise you on in terms of the most up-to-date information, because every other year the state legislature meets, and very often in those sessions laws are updated. So we want to make sure that whatever you are studying is as current as possible based on changing, updated, created legislation, and so forth. We also have a list here of different attorneys who you may wish to consult at some point about drafting or modifying any or all of the documentation that I listed today, keeping in mind that there could very well be more that is suggested for you to consider and complete. But the core of legal planning, I think we've really touched on most of those categories, if not the actual documentation in today's session. But I want you, obviously, not to move forward on anything without licensed legal assistance. So these are people who, over the years, we have vetted. We do not recommend them. We do not, certainly don't discourage you from contacting them, having listed them here, of course. We simply don't make recommendations. We rather go ahead and list people as resources we believe to be credible. And if they are a match for you, that's wonderful. And if so, perhaps they can handle your affairs if that is your wish. I'm going to leave our contact information slide up here for Dr. Peggy Dettermeyer, who is the director of HHCI CARES. Again, our acronym stands for Caregiving, Aging, Resilience, Ethics, and Spirituality. And we are one of the divisions of the Hope and Healing Center and Institute, which, again, consulting our website, hhci.org, you'll have a chance to see not only our origins, but how far we have expanded existentially, not just logistically, since being created by St. Martin's Episcopal Church. We are not of the church, although we do have our office space here on the property. We are a separate 501c3, a nonprofit that serves the entire community. And very often the question is asked, How do I know that you serve a multi-faith, multicultural, multi-spiritual community? I happen to be an ordained rabbi. So there you go. I will leave that statement there for what it is worth. Um, our contact information is listed here, and I encourage you again to make use of it. Or if for some reason you don't have the opportunity to capture the material from this slide, go to our website, click on the About Us tab or on the CARES tab, and you can go ahead and get our direct information again. So ultimately, I hope that the week treats each of you kindly and gently. This has proven useful. And if there is any way you can join us for our final two sessions that have to do with understanding living options and also paying for aging, which is a better way of understanding how our assets, with some pre planning, can be protected as we consider aging in place, the use of long term care facilities, the use of home aid, the prescribed use of home health services, hospice services, and more, depending on our life situation, um, and ensure that our generational needs, let alone future generational needs when it comes to wealth, are managed as best as circumstances permit. I hope that everyone, again, has a blessed week and you all take care.